When you create your will, you don't expect that it will get challenged in probate court. And for the most part, a properly crafted estate plan won't end up in probate court. However, there are some instances where heirs will want to challenge a will. This can be avoided by working with an experienced legal team throughout your estate planning process. But let's take a look at some of the reasons why a will might be challenged. Before we look at the reasons for a will to be contested, let's first look at who can challenge one. Although not all will disputes are conducted in good faith, people affected by asset distribution have rights that they can exercise in probate court. Some of the people with legal standing to oppose a will are a spouse or adult common law partner, adult children of the deceased, any person or beneficiary who can demonstrate an ongoing financial interest in the estate, the public trustee, attorneys under an enduring power of attorney, heirs on an intestacy, and trustees of represented parties. It's a good idea to plan your estate with these potential beneficiaries in mind so that challenges can be avoided where possible. Parties may contest a will for any number of reasons, but there are a few that are the most common. Inadequate support for dependents is one of the most frequent causes for will challenging. If a spouse, interdependent partner, or dependent children are mentioned in the will, it may be contested on the basis that adequate support was not provided. The way in which a will is worded may be another avenue for contest. If the wording used is vague or confusing, it may be up for a challenge. Alternatively, if a dependent believes the will isn't being interpreted correctly, a court may be asked to evaluate the meaning and intent of the will. This could potentially open up the estate for challenge. Wills are frequently challenged on the basis of the deceased mental capacity during the estate planning, and so a will could be overturned if a lack of mental competence can be proven. Another common instance of estates ending up in probate court is due to technical flaws in the will itself, or the validity of the will. Wills must be made in writing and be drafted by a legal adult. It must be signed by the testator or another person under the guidance of the testator. It must be witnessed by at least 2 people in the presence of the testator. And any changes in the will, once it has already been drafted, must be properly signed and witnessed. A duress contestation arises when the beneficiaries can prove that another person pressured a testator into changing the will. This is typically called undue influence and results in the will not accurately reflecting the testator's preferences. Finally, wills can be contested if they are believed to be forged or fraudulent. Unfortunately, forging a will is a straightforward process when it is handwritten. If there is reasonable doubt about the legitimacy of a will, there may be grounds to contest it. In our experience, careful estate planning and trusts are the most effective ways to avoid probate court and any difficulties that may arise. When you consider the importance of estate planning, doing so correctly will provide you with the peace of mind that your beneficiaries will be taken care of when you're gone, with minimal legal costs incurred in court. Trust Kalicki Collier to approach your estate planning with empathy while focusing on clarity and peaceful distribution. Contact us today to begin your planning process and explore your options for minimizing probate loss.